I'm pleased to welcome two of my most respected colleagues here, Ron Wyden and Tom Udall, who have worked so hard and so long on many of these issues, and their work has been so important to me. And I want to say right at the outset that the critical work of intelligence and counterterrorism is of paramount importance to our nation. And it demands and deserves the respect and trust and credibility of the American people, which is why these proposals are important, because they bolster and reinforce the trust and credibility of those institutions, most especially the Foreign Intelligence Surveillance Court. This court is an anomaly in a democratic, open, transparent government. It works in secret, issues its orders in secret, and has been really contrary to the principles of accountability and transparency that underlie democratic institutions. And these proposals are very simple and straightforward: to change the method of selecting judges that serve on the FISA court so that they represent a more ideologically and geographically diverse body, and also to incorporate an adversarial process, a special advocate whose client will be the Constitution. Sadly, the Constitution, more than ever before, needs a zealous and vigorous advocate before the FISA court. And the idea of the special advocate is one that should appeal on a bipartisan basis. It is really a principle of all of our judicial system that decisions are made better when both sides of an argument are represented. The special advocate, very simply, will test, challenge, question the government's case when it seeks some method of secret surveillance and search. It will not in any way delay the process. Speed and security are very important considerations. The special advocate and her staff will be screened beforehand for clearance, top secret. They will be permitted to advocate in the FISA court when asked to do so, where there's an issue of significant law that has to be debated. And they will advocate most commonly before the Court of Review, where those issues of law will go almost certainly. And clearly there are issues of law. The FISA court makes law incontrovertibly. So these principles are immensely important, and already we're finding among our colleagues very strong support for them. This court exercises vast, invisible power that require that we preserve and bolster its trust and credibility at a time when clearly there are doubts, very severe skepticism about the nature of the Foreign Intelligence Surveillance Court process. And I want to introduce someone who has been a champion of individual rights and liberties and proper oversight and accountability in this area, Senator Ron Wyden.
Senator Blumenthal, thank you. And I just want people to know I feel like I'm running with the right crowd, because these two senators, they are very expert in the legal field. I'm basically a lawyer in name only. I ran the legal aid office for a number of years in Oregon, was co-director of the Great Panthers. So these two are real lawyers and practitioners who are very skilled. And Senator Blumenthal, you've done a lot of heavy lifting here. And Senator Udall, great work you did at the state level. All of that has come together as, in effect, these two colleagues kick off the push here to make reforms, essential reforms in the legal underpinnings for these various programs that the public is paying so much attention to. The most important point at the outset to me is this is the court, the FISA court, that took the Patriot Act definition of relevance and allowed it to morph into the collection of millions and millions of phone records on law-abiding Americans. This is the court that, in effect, allowed this new definition of relevance under the Patriot Act to lay bare the personal lives of hundreds of millions of law-abiding Americans. And I think it's worth noting, there was nobody there to offer the other side. So when this dramatic change, a change that I think will be regarded as significant in our country's constitutional history, as Senator Blumenthal touched on, there was nobody there to offer the other side. I know of no other court in America that is so one-sided. I don't know of any other. And for example, you hear often, you can appeal. How do you appeal something that's secret? Even if you get standing, how do you appeal something that is secret? So this is a fundamental premise in what the American people have seen, in recent days, that you have secret surveillance under secret law interpreted by a novel court that's one-sided and that operates in secret. Only their most important holdings ever become public. So I'm very pleased to be here with my colleagues. I think the heart of what Senator Blumenthal and Senator Udall are trying to do is, in effect, to diversify the viewpoints that get addressed in these hearings. That's what the point of this is to unstack the deck and make sure that you're not just hearing one side of the discussion and everybody else just says, well, okay. I'm also very grateful to these two senators because they were part of the more than a quarter of the United States Senate that has been pressing for answers on a host of issues. And this is a critical piece of the reform puzzle that we're going to pursue in the days ahead that ensures that Americans can be both secure and have their liberties.
Thank you. Thank you. Thank you, Senator Wyden and Senator Blumenthal. And let me just say it's a real pleasure working with both of you. You both bring special qualities to this fight, and this is a fight about our civil liberties. It's a fight about protecting our Constitution, and I'm very happy to be standing with both of them and shoulder to shoulder as we move forward. Senator Blumenthal and I both served as federal prosecutors, and we both served as state attorneys general. We both know our courts work best when all sides are heard, and heard by judges with diverse viewpoints. And one of the things that I think these bills do is make sure that we're going to get diverse viewpoints. The adversarial process is a hallmark of American justice, but the FISA court only hears one side, the government side, and that's really the problem. And I've said this before, but I think it bears repeating. It's impossible to judge whether our Constitution is being violated when we have a secret program overseen by a secret court making secret decisions. And that's what we're trying to deal with here today. These bills do not compromise national security, but they put a necessary opposing view in the FISA court and assure ideological diversity of judges. As Senator Blumenthal has noted, only a handful of surveillance requests have been turned down by the FISA court. Only 11 out of 34,000. The judges need to hear all sides, not just the government's. That is crucial to making an informed decision and to functioning as a court, not a rubber stamp. And I applaud both senators for these important bills and very much appreciate working with them on these. The reform effort is going to be a difficult one because, as we have seen from earlier votes, it's a slow process. But I think The three of us working hard with the additional co-sponsors we've already had in this very short period of time, we're going to be able to get this done for the American people. Thank you, and I think we're open for questions at
We
this
are
point.
indeed.
Yeah.
Yeah.
Thanks. Spencer Ackerman with the Guardian. If the special advocate's client is the Constitution, what, if any, role would the advocate play in cases before the FISA court for surveillance that might not implicate constitutional boundaries, like under so-called regular FISA? Does the advocate play any role? And relatedly, what mechanisms are you going to put in place to ensure that the special advocate doesn't become, for lack of a better term, part of the problem? Presumably these are qualified federal judges who sit on the FISA court, and they don't mean to be rubber stamps or so, for lack of a better term. So is there a mechanism that would ensure its adversarial nature, aside from just the simple fact of its creation?
Well, I'm going to yield to Senator Udall and Senator Wyden, but let me just take a first crack at it. And they may have different answers because these bills are still very much a work in progress. And the basic concepts are set, but there are additional details that can be added, and we welcome those views from co-sponsors and others during this process. But the basic idea is that almost all of the issues before the FISA court will in some way implicate constitutional rights, if only because due process is at stake. So a FISA court judge who thinks that an opposing point of view should be represented either after or even before a warrant is granted can call on the special advocate to be involved. And as for the accountability of the special advocate, if there's evidence, such as we've just seen, 11 rejections out of 34,000 certainly sends a message that's important for perception, if not reality. Obviously, the intelligence community is very vehement that the court always pushes back, but we don't have any insider evidence, which is why greater transparency is important, as all of us, and most certainly these two champions of transparency and accountability have advocated.
Yeah, just to say it just a little bit differently, I think if you have, and I don't disagree with anything both of them have said, if you have an advocate in there that's focus is the Constitution and civil liberties, then it unleashes the court to be able to do the job that typically courts do, which is weighing and balancing. When you only hear from one side, that's where you run into a problem. And many of the times, I'm sure all of us here will realize where you've had ex parte proceedings, where you've had one side cut out, that's usually where you get injustice. And it's usually where you get bad decisions.
The only thing I'd add, Spencer, is this is the next logical step because past efforts haven't worked. For example, in 2009, the Obama administration wrote Senator Rockefeller and I saying that they were going to begin an effort to start redacting some of the legal underpinnings in FISA court decisions. And I've said, since I sit on the committee, I'm absolutely convinced that you can separate out secret operations from secret law. There's a big difference. Operations have to be kept secret, but the laws ought to be public. And given the fact that after that pledge was made in 2009, that the Obama administration would start the process for declassifying the legal analyses, as of today, not a single one has been declassified, not one. That's why I think what Senator Blumenthal and Senator Udall are talking about is so important. It is the next logical step.
Yep.
Is there anyone in the House that you're going to write similar legislation? What do you think about the bill's prospects in the House?
In the House? Well, I think that the measures that have been proposed by the House on judicial selection, for example, the selection of the FISA judges, are an effort to achieve the same goal. They do it in a little bit different way. I think that the use of the chief judges of the 13 circuits in this country is a way to introduce greater diversity and geographic differences. And I think that very, very importantly, you know, we're talking here as much about perception as reality. And right now, Americans would be absolutely astonished, and most of them don't know, if they knew the Chief Justice of the United States, alone, without any accountability, without answering to anyone, appoints all of those judges that then in secret decide these fundamental core constitutional issues. So the House is moving in the right direction. I think this bill has some very significant proposals, and we'd be happy to talk to them.
Assuming that you're going to visit with the president today, if those of you who are, do you think that there has been some surprise on the part of the administration and the intelligence community? First of all, the closeness of the vote in the House of Representatives last week, the sort of uprising, for lack of a better word, in Congress. I mean, the conventional wisdom is that the public, this is what they're required to keep us safe, then that's what they have to do. What was the initiative to call this meeting today? Do you think there is a heightened concern? Do you think that the administration is now more willing to go along with some of what you're proposing than they might have been before all of this happened in Congress?
Well, I'll let Ron answer that after but certainly there is a great receptivity in the administration to these ideas. I've talked publicly and privately. I don't know whether you were at the hearing yesterday of the Judiciary Committee, but there was bipartisan interest in this idea of a special advocate or the adversarial process. And I think the representatives of the administration there were extremely receptive to say they are going to be thinking about and considering these kinds of proposals.
I'm going this afternoon. I appreciate the president making the opportunity available, and he's indicated that he wants to listen and walk through some of our proposals. And the fact is that the debate in the House of Representatives would not have taken place 8 weeks ago, number one. Number two, you certainly wouldn't have seen 200 members of the House of Representatives vote for fundamental reform, and you wouldn't have seen a host of the other developments. I never imagined, for example, that we would see the NSA take down a fact sheet, which in our view, one of the other Udalls, Mark Udall, that he and I thought exaggerated the privacy protections that were available in the law. And I think what's happened is the American people have figured out that so often in the past this has been about false choices, that you can either have your security or your liberty. And I think all of us would tell you that when you go home, whether it's a senior citizen center or a lunchroom at a company, I mean, people have asked me, folks, about FISA in the barber shop. None of us could have conceived getting a question about the FISA court at all, number one, and certainly not having people, come up and ask about it. And the only other thing I'd say is my view is people see that this is a unique time in our constitutional history. You have had a merger of these extraordinary surveillance authorities that lay bare people's personal, lives, with the ability to conjure up these legal theories, for example, that redefine relevance beyond what anybody could imagine. And then you couple that with the court that Senator Blumenthal and Senator Udall are talking about so eloquently that is so one-sided. That is an unprecedented opportunity to influence the personal lives of our people, and I think that's why our side is going to prevail in terms of getting key reforms.
Just quickly, I'm not surprised. I'm not surprised at all, because when you go back home, and I think we would all be able to tell you many, many stories here. This is what people are interested in. After the disclosures, after the front page pieces, when I go home, people say, are they really collecting this kind of information? Does this court operate this way? What are you doing about this? So I'm not surprised at all, and I think one of the driving forces here is the American people caring about their Constitution. And the president now, for months, I think, has welcomed this discussion. Some of us here have had discussions with him about these issues. I applaud him for stepping forward and starting to listen to people and moving the dialogue along, because this is something that needs to be taken care of, and we want to make sure we do legislation that he's going to sign when it gets up there.
These two have my proxy, because I think we have a vote, but.
Do we have enough?
Dick,
Not yet? Okay.
Should we?
Yes.
Do you think that there's so much anger coming out today about Edward Snowden in Russia? Do you think that it's going to make it a harder sell to the public and to your fellow lawmakers, this whole, the transparency movement?
You know, that's a very interesting question. I've been a prosecutor and a law enforcement official for some time. You know, people want to get the bad guys. They have no tolerance for people who prematurely disclose facts that endanger our national security, but tell them that their phone numbers have been collected by the government when they know they're not one of the bad guys and they have no tolerance for bad guys doing bad things, and they are appalled and astonished. So I think the American people are capable of separating the illegal, completely intolerable actions of a lawbreaker like Snowden from the legitimate concerns that are expressed about protecting individual rights, just as they do in the common criminal context. You know, we have ex parte, which means secret, obtaining of warrants in this country. But eventually, if evidence from the search or surveillance is sought to be presented in court, there's a public hearing, there are two sides, there's an argument, there's litigation, and a court judges based on the two sides that are presented in public. We have nothing like that when it comes to the FISA court, and that's why it's such an anomaly. We're going to take one more.
Yeah, let's take one more.
Okay.
Yeah, go ahead.
As more disclosures come out, it seems that intelligence officials, what they're saying in public doesn't match what's going on in secret. You talk about perception of the FISA court. What about perception of the NSA and intelligence agencies itself? Is there any legislation or push to hold people who may have misled Congress accountable for that, such as D&I Director Clapper?
I think the laws are on the books that would do that. I don't think there's anything that further needs to be done.
Well, you know, let me just say, we're here about, and I hate to be sort of technical and abstruse, but, you know, the measures we're proposing are about process. They're about improving the process for protecting constitutional rights. The Constitution needs zealous advocacy, and this special advocate would be an advocate. The Constitution would be his or her client, and the FISA court doesn't do prosecutions. Holding accountable any officials would be a decision by the Department of Justice. Thank you all.
Thank you very much. Thank you.
Thank you.